What is an affirmative defense and who proves it? Imagine sitting in a courtroom, hearing the judge say, the defendant admits they did the act, but they have a reason that excuses or justifies it. That's the core idea behind an affirmative defense. It's a way for someone accused of a crime to say, yes, I did it, but I have a good reason why I shouldn't be punished. This is different from just denying the act happened. Instead, it accepts the act but adds new facts or legal reasons that could get the case dismissed or charges reduced. For example, if someone is charged with assault, they might admit they hit someone but claim it was self-defense. They're not denying hitting the person, but they're saying they had a good reason to do so. That's an affirmative defense. It's like saying, I did it, but I had a valid excuse. There are many common types of affirmative defenses. Self-defense is probably the most well-known. Others include insanity, where the defendant claims they didn't understand what they were doing, or necessity, where they say they committed a crime to prevent a bigger harm. There's also duress, where someone claims they were forced to act because of threats, and statute of limitations, meaning the case was filed too late. Sometimes, defendants argue they used reasonable force to protect their property. Now here's where things get interesting. In most criminal cases, the prosecution has to prove the defendant is guilty beyond a reasonable doubt. The defendant doesn't have to prove anything. But when an affirmative defense is raised, the rules change. The defendant now has the responsibility to prove their defense. They must introduce evidence supporting their claim and show it's more likely true than not. This is called proving by a preponderance of the evidence. So, if a defendant claims self-defense, they need to show facts like they reasonably believed they were in danger and that their response was appropriate. They might bring in witnesses, physical evidence, or expert opinions to support their case. The prosecution doesn't have to disprove the defense. Instead, the defendant must prove it. Timing is also important. Usually, the defendant must notify the court and prosecution early, often within 10 days before trial, that they plan to use an affirmative defense. If they don't, they might lose the chance to use it later. They also need to clearly state what facts support their defense and present credible evidence to back it up. From a legal strategy point of view, raising an affirmative defense can be powerful. It can keep a defendant in the case even if the prosecution has strong evidence. Sometimes, it can lead to a plea deal or even an acquittal. Defense lawyers work on these strategies early, gathering evidence and negotiating with prosecutors. It's important to understand the difference between a standard defense and an affirmative one. A standard defense challenges whether the prosecution proved all parts of the crime. An affirmative defense admits the act but argues there's a good reason why the defendant shouldn't be held responsible. In the end, the person who must prove an affirmative defense is the defendant. They need to show it's more likely than not that their reason or justification applies. This shift in burden makes it essential for defendants to have skilled legal help. Without proper evidence and presentation, an affirmative defense might not succeed. So, in court, it's all about who can make the best case with the facts and the law on their side.